Anyways, I guess what we'll do is, did you want to say anything, Nelson?
No.
Okay. Okay. Okay, well, I was going to do a little presentation on the nature of federal jurisdiction in Texas. And there we go. Aim the camera right here. So this is a Word file. This is actually a filing that I filed into a recent federal court case. I was down in the court yesterday and they dismissed it, which I expected them to, quite frankly. They seem to be sympathetic, but they're not a real court anyways. But I got everything in there that I wanted for the appeal, and so I think I'll have, and we'll see what happens. You know, I think I'm prepared to take it to the Supreme Court. Maybe the Supreme Court wants to hear it. I've been to the Supreme Court 5 times, so maybe it'll be 6. We'll see.
What did you file?
I had a lawsuit filed in August in the federal court over property taxes. Anyways, this is part of one of the filings that I filed. Texas codes are in the Commerce Clause. Under Article 1, Section 8, Clause 3, if you look at the Texas Tax Code, Section 151.004, it says, in this state, means within the exterior limits of Texas, and includes all territory within these limits ceded to or owned by the United States. So anytime the word in this state is used in any statute in Texas, this is what it's talking about. All territory within these limits ceded to or owned by the United States. And includes is limiting. Okay, this is a Supreme Court case, Montello Salt versus Utah. Include of the participial form thereof is defined to comprise within, to hold, to contain, enclose, comprise. So that's it. There's nothing else in there. Okay, so it's all territory within these limits ceded to or owned by the United States. That is all that is within this state. And here's a law dictionary definition, Black's 6th edition. Same thing. Confined within, hold as an enclosure, take in, shut up, contain, enclose, embrace. So, which means that when they use this phrase in the state in their codes, it's only talking about territory ceded to or owned by the United States. And all legislative, inferior, municipal, fake court judges are 14th Amendment U.S. citizens, practice law only in federal areas of Texas. This is Texas Government Code, Section 3006, 30.006. A municipal court of record is presided over by one or more municipal judges. The judge must be a resident of this state, be a citizen of the United States, be a licensed attorney in good standing, have 2 or more years experience of practicing law in this state. Okay, so lawyers only practice law in federal areas of Texas. An assistant prosecuting attorney is licensed to practice law only in federal areas of Texas. This is Texas Government Code, Section 41.103. An assistant prosecuting attorney must be licensed to practice law in this state. To qualify for an appointment, all judges practice law only in federal areas of Texas. Do you know why? Do you know why it's only in federal areas of Texas? Does anybody know why?
Because it's outside the one, they're saying it's the 1817 area.
Because all courts are federal courts.
Because Texas is under a military occupation. Has been since 1861. Okay? It's martial law. That's why. So you're right, Nelson, but it goes more to the fact that we're under, Texas under military occupation, but it's only federal areas of Texas. And because Texas is under military occupation, it puts Texas under as federal territory, okay? So Texas is federal territory, which brings us into the Northwest Ordinance, okay? Because the Northwest Ordinance defines the nature of federal jurisdiction and federal territory. And so, again, still, it's only federal areas of Texas. That's why they use the zip code. All these courts have a zip code, and they want Federal Reserve notes. That's all for District of Columbia only, Article 1, Section 8, Clause 17.
So is their claim true then regarding the martial law means it extends over all areas of Texas, therefore it's all federal?
No, it's just federal areas of Texas. Because common law, under the Northwest Ordinance, they're supposed to give us common law.
Gotcha.
See what I'm saying?
So it reverses.
So they drag you into their commercial court. It's all Commerce Clause. It's all Commerce Clause. They bring you into the Commerce Clause. And so, but that's how you defeat it too. Okay, Article 1, Section 8, Clause 17. And that's what I've been bringing up. I bring in all this stuff in this federal court case numerous times. So we'll see what happens when it goes to the Court of Appeals. Anyways, and we'll set it up. It's being set up for the Supreme Court. So we'll go there too. I don't have a problem with that. All judges practice law only in federal areas of Texas. Qualify for an appointment as associate judge under this chapter, a person must be a resident of this state, one of the counties the person will serve, have been licensed to practice law in this state. All bar members are allowed to practice only in federal areas of Texas. Board of Law Examiners, Texas Government Code, Section 82.004, acting under instructions of the Supreme Court provided by this chapter, shall determine the eligibility of candidates for examination for a license to practice law in this state.
Excuse me, so would that mean that a judge, because he's a bar member, he's in violation acting against a man as well? Would a judge by definition, since he's an attorney?
Well, they're dragging you into their federal territory is what's happening. Okay, but it's only areas owned or ceded to the United States. And I don't believe there's been any areas, Randy says there has been land that's been ceded to the United States and Texas, but I don't think so. But even if there was, it would be like Fort Hood. It'd be a military base, which we're not in a military base here. And if it's owned by the United States, okay, then that means the federal courthouse, okay, which means, doesn't mean here. See what I'm saying?
Post offices, especially.
Post offices could be, yep, for sure.
I did find that out to be true in the state I'm currently domiciled. The local post office was actually ceded by the legislature to the United States.
So what he's saying for the people on YouTube is he said that the post office was ceded by the legislature in New Jersey to the United States. So, and that's important. So it's good to know. But, you know, I never have any trouble in the post office.
So true.
Anyways, all bar members are allowed to practice only in federal areas of this state. I already went over that. All juries are only for federal areas of Texas. The Office of Court Administration of the Texas judicial system shall develop and maintain a model for the uniform written jury summons in this state. That's why they want to know if you're a U.S. citizen, and that's the quickest way to get off the juries. All you do is tell them I'm not a U.S. citizen, and they'll kick you out of there so fast your head will spin. All law enforcement agencies are only in federal areas of Texas. Texas Code of Criminal Procedure. Law enforcement agency means any agency of the state, of a county, municipality, or political subdivision of the state that employs peace officers to make motor vehicle stops or routine performance of officers' official duties. Each law enforcement agency in this state. All arrest warrants are effective only in federal areas of Texas. Code of Criminal Procedure, Article 15.06. A warrant of arrest issued by any county district clerk or by a magistrate, except mayors of an unincorporated city or town, shall extend to any part of the state, and any peace officer to whom said warrant is directed or to whose hands the same has been transferred shall be authorized to execute the same in any county in this state. All search warrants are issued only in federal areas of Texas. A search warrant is a written order issued by a magistrate and directed to a peace officer commanding him to, it's interesting to go back to this other one, a warrant of arrest issued by any county or district clerk, okay, those are actually capiouses, or by a magistrate, except mayors of incorporated city or town. See, technically a mayor is a magistrate, so what they're saying is a mayor cannot issue a warrant. That's what they're saying right there. Anyways, all search warrants are only in federal areas of Texas. A search warrant is a written order by a magistrate directed to a peace officer commanding him to search for any property or thing and to seize the same and to bring it before such magistrate and command him to search for and photograph a child and to deliver to the magistrate any of the film exposed pursuant to the order. Those search warrants shall issue for any purpose in this state, unless sufficient facts are first presented to satisfy the issuing magistrate that probable cause does in fact exist. The Texas codes are effective only in federal areas of Texas. This is Texas Code of Criminal Procedure, except as otherwise provided in Article 54.02, all laws related to criminal procedure in this state. All government agencies and political subdivisions are only in federal areas of Texas. Human Resources Code, Section 201.004, to improve services to youth, the department may cooperate to contract with the federal government, federal agencies in this state. Federal government agencies in this state. So government agencies are all in federal areas of Texas. Texas Civil and Practice Code is only for federal areas of Texas. This is Texas Civil and Practice Code, Section 501, Rule of Decision. The rule of decision in this state. So, again, federal areas of Texas. That brings in, actually, if you think about it, that also brings in the Northwest Ordinance. They're supposed to give you common law, theoretically, but they never do. The demand heard that there are no federal enclaves in Texas. And that's U.S. versus Bevins, talks about federal enclaves, which is ports and dockyards ceded to them. So some states have federal enclaves. If there are any in Texas, it would be like military bases. You know, but I don't believe there are any. If you do a Google search, you know, nothing will come up. The state of Texas has authority that exists by its own authority, or is introduced by its permission. That's McCullough versus Maryland. And the demandant was not created by Paxton's bar members, nor Paxton, nor the state of Texas, nor the United States. In fact, the opposite is true. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. After Congress passed the act that precipitated all of this, at 12 Stat 292, the Texas legislature passed an act defining what money and property is, subject to taxation or exemption, and the mode of listing the same on August 21st, 1876. And this is Section 1 of the act. Be it enacted by the legislature of the state of Texas that all real and personal property in this state, the property of corporations, and I think that should be now existing. The property of corporations now existing or may hereafter created, and the property of all banks and banking companies now existing or may hereafter created, and of all bankers, which is corporate-owned property. In Section 4, the term person, whenever used in this act or any other act relating to the assessment or collection of taxes, shall be construed to include firm, company, or corporation. Anyways, so that's the nature of federal areas in Texas. And this stuff, there's the Texas Government Code says that the separation of powers, the Texas actually Constitution, well, this is a bunch of crap because they just ignore it all the time. I think with the regime change in Washington, I think there's going to be, the changes are going to start filtering down. I know that a habeas corpus, Brian Cole, you know, he's been here a few times with his dog. He did a petition for writ of mandamus in federal court, and under federal rules, you know, the mandamus has been abolished, and but the court said, reading this liberally, the court answered, and they said that we don't do mandamuses, but reading this liberally, see, Brian was out on bond, okay? So this is important to know, because when you're on bond, you can do a habeas corpus, because the court actually said that he's out on bond, and reading this liberally, it looks like he's possibly doing a petition for a writ of habeas corpus. So he actually gave him till the 5th of March to submit it's a 28 USC section 2241 habeas corpus, which is for prisoners, and do a petition for writ of habeas corpus. So we went and actually filed 6 of them, because there's 6 different charges he's got all over the place. Habeas corpuses, I know, he's like, you know.
What is that going to do for him?
Well, the judge asked us to file a petition for writ of habeas corpus, so who knows, you know. But one thing we brought up is it's a bill of attainder, okay? And we attached, I made a memorandum of law on a bill of attainder. It's a non-judicial proceeding, and so therefore it's unconstitutional, and they're not giving him common law, and so we want it dismissed. We want the case dismissed and him released from jail. And so we'll see what happens. I mean, you know, how long it takes, I don't know. But there's the judge actually acts. That's Reed O'Connor, that's the judge in my case. Now, what happened as far as it getting dismissed is the magistrate judge. See, so don't ever accept a magistrate judge is what you should probably do, is just don't accept a magistrate judge, and because what they're doing is they're setting you up, because what happens is, so this magistrate judge dismissed it, but he doesn't have any power to do anything. All he can do is make recommendations for the regular judge, okay? And so now he's made his recommendation, and so I have to rebut. I'm going to file something. I'm still thinking about it, but I got 2 weeks. I got 2 weeks to file something, and so I'm going to file something and rebut his judgment, okay, or decision, and then the real judge is going to issue a ruling, either agreeing with the magistrate or you know, modifying it somehow, you know, and whatever. I don't really care. The important thing is that I got the stuff on the record for the Court of Appeals, because now it's going to go to the Court of Appeals. You know, they have a thing called the law of the case, so you don't ever expect, and this is one thing that Randy Kelton says all the time, is don't ever expect the lower court to ever do justice. You know, they don't do justice in there. They're a bunch of, you know, he doesn't say they're a bunch of thieves, but I do. Anyways, so what you got to do is set it up for the appeal. And so, because the appeal court is required to maintain the case law. And the lower court, it's called law of the case, which if you don't dispute it, then you've agreed to it, okay? That's really what it comes down to. And so they're just, that's what I say, they're a bunch of pirates. So we'll go to the Court of Appeals, and I'm setting it up. I got to set it up right though. I was thinking about filing a notice of contempt. You know, I have nothing but contempt for you and your so-called court. But if I do file that, it's going to be after the appeal package has been sent to the Court of Appeals. Because I don't want the Court of Appeals to see that. You know what I mean? And so, yeah. So, anyways, so we'll see. You know, we'll see. Reed O'Connor is the judge in my case, and I already sent him 2 nasty grams. I sent him one in 2020 and one in 2021. And, you know, my nasty grams start off and it says, normally I say accept your oath of office, but you and I both know you have no intention of honoring an oath of office, so fuck your oath, you lying, perjuring motherfucking son of a bitch. And there's like about 20 pages of that. You know what I mean? Yeah, I sent that to Reed O'Connor in 2020 and in 2021. So, matter of fact, the clerk sent it back and said, you've got several cases open here. We weren't sure which one to file it into, so write the case number across the top, and if it's in more than one case, make copies. I can show you. I can show you copies of it where they sent the. I'll find it for you. Anyways, so yeah. So anyways, you know, my attitude is that. My attitude is that, let's see here. Let's go here. Oh, here, that's where I'll go. Right here. So, here we go. This is 2020. I sent this one to Trump. Both of them, I think, got sent to Trump. Right here. This is the letter from the clerks. See here? It says, Fort Worth Division. You have more than one case pending in the Northern District of Texas, and your documents do not provide a case number. Please write the case number on your document, return them for filing. The document may be filed in only one case. If you want to file it in more than one case, you must file separate copies for each case. So anyways, so, you know, the courts are helping me. I found the courts to be very helpful. So, anyways, let me put this up on YouTube. There we go. So that it goes to YouTube. This is the letter the clerk sent me back in 2020. So we're getting some chat here. Let's see what the chat is. Yeah, they're a bunch of thieves. Don't get me going. You're going to get me going. So anyways, the bottom line is that you know, we'll see what happens. This is every time I've been into the federal courts, this is the kind of stuff that happened. But then when I went to the Court of Appeals, it was more favorable. And now when I go to the Supreme Court, because I attached that common law court decision to the lower court, so that's going to be included in the Court of Appeals, and I'm going to attach it to the Court of Appeals too. So you know, I expect that I might get a good decision out of the Court of Appeals. We'll see. And if not, we'll go to the Supreme Court and we'll see what they have to say about it. If they, every time I've been to the Supreme Court, I told them you didn't have any, it says right in their rules they can turn any case away. I told them you didn't have any right to turn the case away and you didn't have any right to tax me, and they accepted every case. Now I know people that have had their case turned away by the Supreme Court and it doesn't even get docketed. And I have docketing letters for every one of my cases. The Brunson case, they did it exactly the same way they did mine, but it's still waiting to get heard for some reason. I'm not sure why. But so we'll see what happens there. But I tell them, you don't have any right to turn this case away, and you don't have any right to tax me. And so they accept the case every time. I get a docketing letter. I have to send a docketing letter to the Solicitor General, because that's who represents the United States. And then so there should be a different Solicitor General in there now. We'll see what happens with that. And then what happens is in the other cases, see what they do, the Solicitor General waived their right to respond. And I believe they did that with the Brunson case too. But I think that the judges said that we still want to have a hearing on it. And so that's the last I've heard about it, but I've heard that it's still pending in the Supreme Court. So we'll see what happens with mine. I think there's regime change happening for sure, so the Solicitor General might treat it differently. I guess we'll see. But that's all I can say. But it'll cost them, because they'll have to hire a lawyer, okay, to go to the Supreme Court. It'll cost them millions, okay, to go to the Supreme Court from a lawyer. And so, whatever. I don't give a shit that what it costs them. And I haven't heard a peep out of them about property taxes since. And so I bet you they're already getting told. But I'm not done with them. So we'll see. That's all I can say. We'll see what the Supreme Court says. I can tell you that I sued Nathan Hecht in his private capacity, and the Attorney General responded, and I went and did a motion to strike because I'm suing him in his private capacity, and I said that they're misappropriating public funds. And so then the Attorney General responded again another time and said that they can certainly settle a matter for the Supreme Court. And I said, I don't want a settlement. I want his bond. Not a penny more, not a penny less. He's not doing his job, so maybe he shouldn't be doing that job. Maybe he needs to be digging ditches or something like that. Or maybe he can live in a cardboard box, which is what he's trying to do to me. That Bible says he's supposed to get the punishment he's trying to do to other people. Anyways, Randy Kelton told me about a week ago that he had resigned, okay? And it's interesting to note that Randy Kelton had sued him, but Randy does it a little bit differently. Randy shows his political agenda. He says, I'm a talk radio host, and so they automatically take it that he's doing it for his program. See what I'm saying? And so they dismissed it as frivolous, and then he went and took it to the Court of Appeals, and they dismissed it as frivolous, and so now he's suing the 3 judges on the Court of Appeals in their private capacity. So we'll see what happens. But the bottom line is that I'm not coming that way, okay? I'm saying I'm posterity. Will Livingston's my 4th great uncle, and they're liable in their private capacity, and I want their bond, and I want this common law judgment enforced, and so we'll see what happens. That's all I can say, But I'm still thinking about doing that, filing that. But I'm going to wait till it's not going to go to the Court of Appeals, and so I'm going to have to be nice. I'm going to have to be polite for my response. Well, see, he actually said it's without prejudice, which means I can rebut some of the stuff he said, which I'm gonna, for sure. I haven't even got it. I was down in the courthouse yesterday and I read it. It was in the mail hasn't caught up with me yet, so I'll wait till I get it. Anyways, so that's about it for me. Does anybody else have anything?
I'd be willing to talk some more if anyone wants to hear about the organic law.
Nelson could do a presentation on organic law. What time is it? Well, it's early. It's still 1:30. Why don't you go ahead, Nelson?
Okay, how about a 10-minute break?
Yeah, let's take a 10-minute break, and then Nelson will talk about the organic law.